Hello, everyone. On behalf of the program on extremism at George Washington University, I'd like to welcome you all to today's virtual event on returning and repatriating foreign fighters from Syria and Iraq. For those of you who don't know me, my name is Bennett Clifford. I'm a senior research fellow at the program, and I'll be moderating today. This should be an excellent event. We'll hear a range of perspectives on what has become a very timely issue. As I'm sure many of you all are aware, during the past few weeks, we've heard announcements from the Department of Justice in the United States that in total, the US has repatriated 27 individuals from the battle space in the Levant. They also very recently brought back 2 British ISIS fighters, notoriously known as part of the Beatles, for trial. But we've also seen policy movement in a number of other Western countries, including, but I'm sure not limited to, Italy, Canada, and France. Today, we'll be looking at the issue of returning fighters from 3 different angles. We have the political lens that governments are using to make decisions about whether to repatriate or prosecute their returning foreign fighters. We have questions about the legal standards and difficulties therein for governments to prosecute them in court. And finally, an interesting perspective from the other side of the ball field, how the Salafi jihadist groups themselves are viewing the situation of returning foreign fighters and how they're inclined to respond. To present these different perspectives, we have 3 excellent panelists. I'll introduce them in the order that they'll be speaking today. First and foremost, we have Dr. Elena Picalova. She is a professor and chair of the International Security Studies Department at the College of International Security Affairs here in DC at the National Defense University. She's also the author of an excellent book on this subject, Returning Islamist Foreign Fighters, Threats and Challenges to the West. Second, we'll have Tanya Mehra. She's a senior project leader and senior research fellow at the International Center for Counter-Terrorism at The Hague, as well as a fellow at the Program on Extremism. Finally, we'll have Marta Furlan. She's a PhD candidate in international relations at the Handa Center for the Study of Terrorism and Political Violence at the University of St. Andrews. So we'll have an event runtime of about an hour, and I have 2 quick moderator's notes before we start. First, this discussion is being simulcast to our YouTube channel, and it will be available in permanent URL form after the event. Second, after our panelists give their presentations, we will open the floor up for question and answers. Please use the chat function at the bottom of your screen on Zoom to enter questions for our panelists. During our question and answer period, I'll select the question and pose them to our panelists and hope to get through as many questions as possible during the event. So without further ado, I'll turn the floor over to Dr. Pokalova for her insight on the political situation facing governments' decisions to return and repatriate foreign fighters.
Thank you, Bennett. And first of all, thank you to Lorenzo Bedino and his team at GW for hosting me here today. I also have to say that the views that I will share are my own and do not represent the position of the National Defense University or the US government. Today, I will share with you some of the insights that I got through working on this book on returning Islamist foreign fighters. Now, my observations are about Islamist foreign fighters and returnees and might not be applicable to foreign fighter returnees of other ideological orientations. So if you look at Islamist terrorist attacks in the West prior to 2010, very few of them involved foreign fighter returnees. Mostly they were acts committed by domestic extremists or relocators or people who went to certain countries in order to commit terrorist attacks, such as in the case of September 11th. This situation changed with the rise of ISIS. And specifically, following the involvement of the US-led coalition in Syria and Iraq, the then ISIS spokesman Abu Muhammad al-Adnani called on followers to attack Westerners both in Syria and Iraq and in the West. And those were not empty threats. Since 2014, we actually see a wave of terrorist attacks directly targeted against European countries. Some of these attacks included the May 2014 attack on the Jewish Museum in Brussels. In August 2014, there was an attack on a train in France. There was an infamous wave of terrorist attacks in Paris in November 2015. And in March 2016, we had the bombings in the Brussels airport. While some of those attacks immediately looked like acts of lone wolf terrorists, investigations soon revealed that in all those cases, ISIS operated through foreign fighter returnees. Specifically, in these cases, ISIS employed its Amni unit that was specifically focused on using foreign fighters as agents to stage terrorist attacks in their countries of origin. The attacks and the investigations into these attacks led security services to the figure of a Belgian foreign fighter, Abdelhamid Abaoud, who at that point headed Amni unit and handpicked foreign fighters to come with him back to Europe to stage these attacks. So naturally, such attacks and further ISIS activities caused fears that foreign fighter returnees would similarly be dangerous for their home countries. Also, back in 2017, Interpol circulated a list of individuals who were allegedly ISIS trainees on their way back home to home countries, and they were allegedly coming back with the intent to stage similar terrorist attacks. Also, a lot of Western security services raised alarms about foreign fighters who could have sneaked back early on into their countries of origin and now could be staying low until further instructions from ISIS to stage further terrorist attacks. Such concerns were also amplified by the fact that prior to the rise of ISIS, many Western security countries did not pay much attention to foreign fighting and foreign fighting phenomenon. Foreign fighters themselves were rarely tracked, and foreign fighting was not considered a crime in many instances. So this meant that traveling to Syria and Iraq was not a prosecutable offense back at home. As a result, this led a lot of Western governments to attempt to deal with the returnee problem by preventing foreign fighters from becoming returnees in the first place. And some Western countries favored the so-called shoot to kill approach, in which countries attempted to eliminate foreign fighters on the battlefield itself. For instance, countries such as the US, the UK, Australia, and France favored such approach. And while it was not an official policy, the approach meant that these countries cooperated closely together to share intelligence and potentially target foreign fighters on the battlefield. Specifically, in this example, the UK and US worked closely together to share intelligence and to target UK militants in the US drone strikes. Among the individuals who were killed in such drone strikes was the infamous jihadi John, or British Mohammed Mwazi. He was killed in November 2015 in a US drone strike. Similarly, Sally Jones, a British ISIS recruiter, was also killed in a US drone strike in June 2017. The situation shifted a little bit once many countries, including Western countries, criminalized foreign fighting in response to the 2014 UN Security Council Resolution 2178 that called member states to develop and implement appropriate criminal strategies to prosecute and penalize foreign fighters. As a result, there was a wave of legislation that criminalized foreign fighting. For instance, in June 2015, Germany amended its criminal code, criminalizing traveling outside the country with an intent to commit serious violent acts against the states. Many countries followed suit and implemented similar measures in 2015 and 2016. Some countries adopted more restrictive legislation, which criminalized travel to conflict zones or conflict theaters where a terrorist group was present. Among such countries were France, Australia, and Denmark. So in these cases, you could face criminal charges if you traveled to Syria and Iraq without government approval. Criminalization of foreign fighting reduced the numbers of outgoing foreign fighters from Western countries. However, such measures did not always adequately address the issue of prosecuting returning foreign fighters, especially in cases where individuals returned prior to 2015 and 2016, and my colleagues will be able to speak more about the issue of prosecution. Now, some Western countries have also attempted to deal with the issue of foreign fighting through revoking citizenship. Some countries like France allow citizenship revocation in cases of naturalized dual citizens. Other countries like Denmark and Australia allow for revocation of citizenship regardless of how that citizenship was received in the first place, whether through naturalization or birth. So in one infamous case, the ISIS recruiter Neil Prakash, a former rapper from Melbourne, he lost his Australian citizenship since the authorities believed that he also held the citizenship in Fiji. Some of the most controversial measures regarding citizenship have been implemented in the UK, where you can lose your UK citizenship if the Secretary of State has reasonable grounds to believe that the person is able to become a national of another country outside of the UK. And this provision was exercised in the very controversial case of Shamima Begum, who was stripped of her UK citizenship. However, in July, just recently, in July 2020, the UK Court of Appeal ruled that she would be allowed to go back to the UK to appeal her case. Today, there are still hundreds of ISIS foreign fighters and their families who are held in Kurdish-controlled detention facilities in Syria and Iraq. And there is still a lot of opposition to their repatriation, despite some countries, like the US, calling on others to take their citizens back. In August 2020, the US vetoed a UN Security Council resolution that aimed to address the fate of remaining foreign fighters in Syria and Iraq on the grounds that the draft did not include a call to repatriate foreign fighters to their countries of origin. In turn, the US Department of Justice issued a statement on October 1st saying that the government has repatriated the last of 27 Americans from Syria and Iraq. However, given the wave of attacks in European countries, in Europe specifically, there still is a lot of opposition to repatriation. For example, in Norway, the coalition government collapsed over the issue of repatriating a woman and her children. Allegedly, in this case, the woman was a supporter of ISIS. Speaking of women, there's a separate set of challenges associated with their return. The first big challenge is that Western security services tend to view women as victims who are less prone to violence than men. And truly, in many cases, this is truly so, where women are victims of violence by men, by their husbands or male relatives. However, there's also a large number of women who went to Syria knowingly in support of ISIS. And some such women served in the brutal all-female morale police unit called the Al-Khansar Brigade. Also, we know that ISIS actively appealed to women to engage in terrorist attacks and even trained some women to commit such attacks and trained such women to prepare for combat roles. So obviously there are certain issues, security issues that are connected to women, but despite this, female returnees often get more lenient treatment by trying to put the blame on either their husbands or male relatives. In cases that have been prosecuted, women often get shorter sentences than their male counterparts. The second big challenge associated with women is the lack of evidence. If we have difficulties in prosecuting male returnees, in cases of women, we just often do not have information about where women were or what they were doing or where they were staying. Even further challenges are associated with the return of children. There seems to be international consensus that really children are the victims in this whole situation of fighting in Syria and Iraq. However, again, ISIS used children and trained them to become the next generation of mujahideen. For instance, the infamous Cubs of the Caliphate unit indoctrinated children and trained them to become fighters. Infamously, children as young as 4 years of age were filmed in execution videos and were trained as ISIS combatants and suicide bombers. So obviously there is a lot of trauma that these children face, and they require a lot of special assistance in transitioning to life without violence. Children also face a lot of stigma back at home, and there needs to be a lot of work to overcome such stigma. Some countries like France have brought their children back. For instance, the authorities repatriated 28 children in March 2019 and an additional 10 children in June 2020. However, other countries have refused to take children back. For instance, in Canada, the authorities claimed that it would be too dangerous for Canadian officials to go into Syria and to refugee camps to provide any assistance for repatriation. Although in the good news, just a couple of days ago, a 5-year-old orphan girl from Canada was allowed to reunite with her uncle in Canada. So there's some progress in that respect. My argument is that Western countries, in case they fail to repatriate their citizens, are actually misplacing the responsibility. We will have, in this case, Syria and Iraq dealing with the consequences of radicalization that took roots on the Western soil. By not repatriating individuals, we are risking to create a new generation of relocating foreign fighters. And we have plenty of historical examples on how relocating foreign fighters have assisted the spread of jihadist ideologies and have negatively impacted local conflicts around the world. Those who stay behind after the end of conflict also might cause problems. For example, in Bosnia, foreign fighters who fought on the Bosnian side received Bosnian citizenship in thanks for their participation in the jihad. However, they stayed after the end of the conflict and participated in the spread of jihadist networks in Europe. And as a result, the Bosnian government subsequently revoked their citizenship. Now, all of this discussion is not to say that all returnees will come back dangerous, and many returnees come back disillusioned. In fact, one of the German returnees shared that he came to the conclusion that this was not the path to paradise, but was in fact a path to hell. And he and similar individuals cooperated with security services in order to attempt to prevent future individuals from doing the same thing. We do have some promises of rehabilitation. In this respect, the Danish Aarhus project offers some insights into how rehabilitation can be constructed. It is not an easy endeavor and it is quite costly, but we face more security threats down the road if we do nothing and leave Western citizens to their own fate in Syria and Iraq. I will stop here and I will look forward to your questions and comments.
Hi, good morning, good afternoon, everyone. My name is Tanya Mehra from very rainy Rotterdam in the Netherlands. I get messages that my internet is not very stable, so hopefully we'll be able to follow my presentation. So thank you, Program of Extremism, for having me as a panelist and also as a fellow. I think Elena already explained the main policy and political considerations. So I would like to focus more on the legal issues, in particular on collecting evidence from the battlefield and how this can be used to successfully prosecute foreign fighters, but also how it can be used to frame the discussion on repatriation, especially among those countries that are not actively willing to repatriate their foreign fighters. So what I will not do in light of time is focus on the legal and the moral obligations of why we should repatriate, but I will try to briefly discuss how to collect evidence from the battlefield, what the impact this could have on the right to a fair trial, and for which crimes FTFs can be prosecuted. So maybe just to reiterate the obvious, prosecutors cannot travel to conflict zones to collect evidence because obviously it's unsafe there. But there are also other reasons. There might be no mutual legal assistance agreement with the country where the evidence is located, or the government is not in control of the area where the evidence is located. And in some cases, the government even might have collapsed. So it would be very difficult to send out a request for assistance in collecting evidence in these kind of cases. But prosecutors can collect information from other sources. For example, international mechanisms, such as the Commission of Inquiries or independent fact-finding missions. So to give you an example, the most recent report of the Commission of Inquiry on Syria reported that all parties to the conflict are involved in human rights abuses and document sexual and gender-based violence crimes, specifically in the area of Afrin and Ras Al Ain regions, by the Syrian National Army Brigade. And another example is the recently established independent fact-finding mission on Libya, which is tasked to investigate the violations committed by all parties since 2016. So the information is collected and documented and stored with the aim to bring the perpetrators to justice. So in Libya also, the eyes are always focused on the foreign fighters which have traveled to Syria and Iraq, but in Libya also there are approximately 3,000 foreign fighters, mainly from African origin, but also in few instances from Europe and Southeast Asia. But considering Libya's geographical location and the ability of ISIS in Libya to exploit the migrant routes, these FTFs could also pose a risk to Europe. So the kind of documentation which is going to be done by this kind of commission of inquiries and independent fact-finding missions can also be helpful for prosecutors. Another mechanism one can look at is the IIM, the Impartial Independent Investigative Mechanism for Syria. This mechanism also collects evidence, and it looks at evidence committed by all parties in Syria. So recently in Germany, a trial has started against 2 former Syrian intelligence officers, which are being accused for crimes against humanity. And this is based on the information they have received from IIM. And this case is the first time that 2 people of the Assad regime are being held responsible for crimes against humanity. And the trial is taking place in Koblenz, and they're being accused for torture in prison, up to 4,000 cases of torture and 58 murders. And a similar case has also started in France, which is also using information from IIM. Another mechanism to look at is UNITAD. And although UNITAD is only focusing, unfortunately, on crimes committed only by ISIL and Daesh and not by the other parties, it is also collecting information and documenting this information. And this kind of information is being collected to in the end to share with national courts or with Iraqi courts, provided that the proceedings will meet the fair trial standards. So according to the terms of reference, Iraq is actually the primary recipient of the information collected by UNITAD. And this raises actually a couple of concerns. First of all, Iraq has still not adopted a law that criminalizes international crimes. Iraq upholds the death penalty, and Iraq is known for the 10-minute trials, which hardly meet the fair trial standards according to international law. So far, UNITAD has actually not shared any information or evidence with Iraq, but UNITAD has shared some information with France, with Finland and Germany, and it has received another additional request from 5 other countries. And in particular, in Finland, a case against 2 Iraqi brothers on appeal, they have been convicted based on the information they have received from UNITAD. So I already slightly alluded to it earlier, but several NGOs are also active in collecting and preserving and documenting human rights abuses in these kind of countries. To name a few are the Syrian Justice and Accountability Center, the European Center for Constitutional and Human Rights in Germany, the International Federation of Human Rights in France, the Commission for International Justice and Accountability, CISA. So to give you an example, in the Netherlands, last summer, a foreign fighter has been convicted for a war crime, for posing next to a dead body. And he has been, this conviction has been based on information they had received from CISA, the Commission of International Justice and Accountability. And last but not least, military evidence. In stricto sensu, this refers to evidence collected by the military from the battlefield. And this raises several challenges. Isn't it better to have a division between law enforcement and military? And does the military know how to collect evidence? And is military evidence even admissible in court? So ICCT has been working on this topic for the last 5 years and exploring how military evidence can be collected and used and shared with national courts in a rule of law compliant manner in exceptional circumstances. So the kind of information military can come across include, for example, documents such as ISIS membership cards, fingerprints from unexploded IEDs, cell phones, computers. So these are a couple of examples of information which can be found on the battlefield. ICCT has, together with UNCTAD, developed guidelines on the use of how this information collected by the military can be used in court. We see now that countries like Australia and Spain have amended their laws to allow the information collected by the military to be used in court. And we also see a steady increase of court cases which rely on military evidence. To give an example is Mohammed Jamas Kwais. He's been convicted for 20 years in the United States based on a ISIS intake form. And similar convictions we've seen in Denmark and in a few other countries. But still a lot more needs to be done, not only in terms of research, but also in terms of training to be able to make sure that military evidence will find its way into the courtroom in a rule of law compliant manner. So Elena also already mentioned briefly that due to UN Security Council 2178, a lot of countries have amended their laws. But the idea is that this kind of information collected for the battlefield can be used, obviously, also to prosecute FTFs for ordinary crimes. I mean, even the 2 remaining Beatle members which have been charged yesterday, they're being charged for terrorist offenses, providing material support, but also for ordinary crimes such as murder and kidnapping. But what is more interesting is that they can also be used, this kind of information, to start prosecuting for sexual and gender-based violence perpetrated by terrorist organizations and for international crimes. And this would allow to give longer sentences. So how does this impact the right to a fair trial if the accused, if this kind of information is being used? So maybe just one step back and just to mention a few words on evidence. Prosecutors obviously need evidence in these kind of cases. The evidence needs to be admissible, credible, and reliable. So admissible evidence means it needs to be relevant, obtained correctly, it has to be documented correctly, the chain of custody needs to be intact. Credible evidence refers to the probative value of evidence. The source must be trustworthy and the evidence must be reliable, so whether the evidence is accurate and precise. So for example, a witness may be credible, but his statement may not be reliable because it has happened many years ago and he might not be, or she might not be able to recall it properly. So the rules of evidence differ from one jurisdiction to another, and there is a big difference on these issues between civil law countries and common law countries. In civil law countries, it's up to the judge to assess which weight to give to this kind of evidence. So when we look at the right to a fair trial, it has many different elements, and in light of the time, I'll just focus just on 3 aspects. The presumption of innocence. So this means that the burden of proof is on the prosecutor and not on the accused. And that, so the prosecutor needs to have enough evidence to prove that the crimes have been committed and not only rely on circumstantial evidence. The second aspect is that the defense also needs to have enough time to prepare his own defense. So collecting and preparing an FTF case can be very complex and time consuming for the prosecutor. And depending on the charges, statute of limitations might even expire. But this also, of course, means that it will cost a lot of time for the defense to properly prepare its case. The evidence might be in a foreign language, or it might be technically very complex. So this is one aspect that also needs to be taken into consideration. And the last and probably the most important is the equality of arms. And this raises all kinds of issues. I mean, the equality of arms basically refers to the fact that the defense should be able to question the evidence which is being put for him and be able to examine, cross-examine the witness. So it raises questions like, how can the defense challenge the information by the military if it is classified? Or how can the defense question a witness statement which has been collected by NGOs? How can the defense question the authenticity or the validity of forensic or electronic evidence? Does the defense counsel have access to a forensic experts? So how can the defense check whether the chain of custody has been broken? So these are some of the issues that maybe come into play. And some of these might be easily addressed by, for example, declassifying intelligence or providing a video link, but others might be more complicated. So to conclude, I think, prosecuting FTFs is indeed challenging, but it is certainly not impossible. And information from the battlefield is finding its way to court. And FTFs are starting to be prosecuted for international crimes, and this is leading to higher sentences. So I agree with Elena, we need to bring back and repatriate foreign fighters, also because they are not foreign to us, they are our own foreign fighters, and we need to take responsibilities for the acts they have committed. And bringing them back, it's a controlled risk rather than leaving them there. And I think illustrating and showing examples of how FTFs can successfully be prosecuted should help countries to reconsider their views on repatriation of foreign fighters. So thank you.
Thank you, Tanya, and thank you to Elena as well for some excellent presentations. Before I turn the floor over to Marta Furlan, I'm just going to make a quick moderator's note, quick reminder that if you have questions for our panelists at any time, please use the Q&A function and type in your questions that you have at any point in time, and we'll get to them after Marta's presentation when the question and answer period opens up. Just a quick note there, please post your questions, which I'm sure this audience has many for our panelists. And without further ado, I'll turn it over to Marta.
Thank you. So I am Marta Furlan. As Bennett said, I am currently a PhD candidate at St. Andrews University. I am writing my thesis on rebel governance, but I also do research on foreign fighters and returnees. And I want to thank the Program on Extremism and GW for the invitation, for organizing this workshop on such important topics, especially after the latest events, as Bennett was mentioning in introduction. And I'm very glad to be here today with Elena and Tanya to discuss those topics. In the framework of today's discussion, I was invited to talk about how Salafi jihadist groups see their own returnees from a strategic perspective. For reasons of time constraints, I will focus on the Islamic State. And the reason for this is that the number of people that have left their home country to join ISIS is both unparalleled and unprecedented. According to the latest, most up-to-date figures, we are talking of between 44,000 to 52,000 foreign affiliates, including those who have died since the time of their affiliation, which makes the current and future challenge posed by returnees from the Islamic State a particularly pressing one. So to understand the strategic value that returnees have for the Islamic State, I would like to begin by taking a step back and looking at the time when the Islamic State was still a caliphate. Back then, in fact, as it was mentioned before by Elena, there were units such as Emni, and there were individuals within the Islamic State that were entrusted with the task of recruiting foreigners, train them inside the caliphate, and then redeploy them or encouraging them to return to their home country. For instance, a UN report revealed that a Chechen-born militant within the Islamic State was involved in training and redeploying Russian-speaking militants from Syria to Russia with the aim of settling up cells and conducting attacks there. Also, during trials that have been conducted to returnees, some information emerged about units responsible for recruiting, training, and redeploying those foreign volunteers back to their home countries. And more recently, according to interviews conducted by Dr. Vera Mironova, it emerged that there were individuals from the Caucasus involved in this planning of external operations, returning foreign fighters to that region. So in other words, it seems that within the Islamic State, there was a sort of mechanism at play whereby the group sought to recruit foreign fighters, train them within the caliphate, and then return them home, or more or less directly. And here, the Islamic State was interested in returning those individuals home because it saw returnees as strategically valuable for the following purposes: strengthen networks of IS supporters in that home country, recruit other sympathizers in that country to the Islamic State ideology and project, potentially having become foreign fighters themselves, perpetrate attack, and support others who were interested in conducting attacks in their home country. And in this latter regard, for the Islamic State, foreign fighters were particularly valuable because of their knowledge of the local environment in terms of institutions, geography, and language. So I don't want to repeat too much what Elena already said, but for instance, the coordinated attacks in Paris in 2015 and the Bataclan, Stade de France, coffee houses and restaurants, the attacks in Brussels in 2014 and 2016 are examples of attacks perpetrated by individuals who trained with Islamic State and then returned back home for the purpose of conducting those attacks. And we can also remember attacks outside of the West in which returnees were involved, such as the attacks at the Bardo Museum in Tunis and again in Tunisia at the beach in Sousse. And also there were plots uncovered in Kosovo in which returnees had direct involvement. These attacks back then were of course praised greatly by the Islamic State, who was hoping to see its returnees as soldiers of the caliphate who would continue the jihad back in their own country directly in the enemy's lands. So for instance, I would like to mention the 14th issue of the ISIS First magazine that devoted the foreword and the first article to the attacks in Brussels. And specifically it wrote, I am quoting, "Brussels, the heart of Europe, has been struck. The blood of its vitality spilled on the ground, trampled under the feet of the Mujahideen." End quote. And it then proceeded to praise the perpetrators of those attacks, calling them knights of martyrdom, praising their so-called generosity, bravery, and describing their return back to Europe to perpetrate the attacks as an act of religious devotion. And similar themes can be found in the 12th issue of the BIC, where the Islamic State is praising the attacks in Paris in 2015. And it is also interesting in this regard to look at a specific case that, again, Elena mentioned before, of Abdelhamid Abaoud, a Belgian national of Moroccan descent who trained with the Islamic State in Syria in 2013. He was involved in creating a network of foreign fighters coming mainly from France and Belgium. They trained with the Islamic State, and then they returned to Europe, and they were involved in the attacks in Brussels and Paris. And unsurprisingly, Abaoud was a figure raised by the Islamic State as a model jihadist. So I believe that if the strategic value that the Islamic State attaches returnees, individuals who can come back home and perpetrate attacks either directly, either by means of providing support to others, was apparent back then. After a final defeat in Baghouz, as the Islamic State has lost territorial control, the group has become even more reliant on supporters overseas, including returnees, to keep its brand alive. However, today the situation is much more complex than it was back then, because many of those returnees are actually people who are disillusioned with the Islamic State, people who want to break with the violence lived during the years spent with the group, who are seeking to reintegrate into our societies. And those individuals for the Islamic State have a completely opposite strategic significance. They are traitors of the Islamic State project. They are failed jihadists, we can say, to the point that for the group, or what remains of the group, they become targets as much as the kuffar are. So this is an important point to keep in mind when trying to put our shoes in how the Islamic State sees those returnees. Also, today it is particularly interesting to see how the Islamic State values women and those who return to their own country. I think with the fall of Baghouz, women have become ever more important for the Islamic State, for the renewal of its project, both those that are still in Iraq and Syria and those who have returned. So again, prior to the final fall of the caliphate, women who could not leave their home country and join the Islamic State were actively encouraged by the group to strike at the enemy in their own country. Today, foreign women who managed to leave the camp of Al-Khol, in which the majority of them are staying since the fall of Baghouz, and return to their country of origin, are seen by the group as a particularly valuable strategic asset. On the one hand, the Islamic State values female returnees as individuals who can return to the home country and engage in activities of recruitment, indoctrination, and create connections between sympathizers and cells of former foreign fighters or current foreign fighters. For instance, some of the women who are currently in Al-Khol said that the Islamic State briefed them, telling them, I am quoting, "Surrender, go back to your countries, get your strength back, and we will start again," end quote. So in other words, female Islamic State returnees have been instructed to prepare for the Islamic State's future, mostly, though not exclusively, by indoctrinating the next generation of mujahideen and muhajirun. So children are an especially vulnerable category of people in this transition, in this moment of time. In fact, in the words of an Islamic State female supporter who was smuggled out of Syria back to her own country, I am quoting again, "We will bring up strong sons and daughters and tell them about the life in the caliphate. Even if we hadn't been able to keep it, our children will one day get it back," end quote. So the Islamic State is encouraging its female returnees to continue to do in their home country what they were doing in the Islamic State when they were raising up children in the group's ideology, according, for instance, to the guideline that the group had published in a booklet, Sisters' Role in Jihad, that became particularly infamous also in the West. And is encouraging those committed mothers who in Al-Khol today are still trying to raise their children in the group's ideology, in the case in which they return back home, to continue to engage in this kind of upbringing. At the same time, when it comes to the potential recruitment that female returnees could be doing for the Islamic State in the home country, it is noticeable that many women who join ISIS from the West, especially from Europe, acquired important roles as online recruiters once they were in Iraq and Syria. They were used by the group to run online platforms in which they were approaching other women back in the home country, talking in the same language, referring to common backgrounds and grievances. And here examples of these are the French Basira Muhajira and the British Laif. So as these women return home, the Islamic State's hope is that this campaign of online recruitment will continue in the home country. On the other hand, ISIS values female returnees also for their potential engagement in or support to terrorist attacks in the country of origin. For instance, emboldened by this Islamic State rhetoric, a female member expressed the desire of her and her sister to put on a Susa belt and target the cities where the apostates live. So I believe that understanding what is the Islamic State perspective, view, or even hopes when it comes to these returnees is particularly important to develop better terrorism threat models, to be more aware of all the challenges involved. And as far as the insertion of returnees in our terrorism threat, important to emphasize before by Elena, The fact that for the Islamic State, this is the strategic hopes attached to returnees in many cases, should not mislead us into thinking that all returnees pose a security threat. In fact, as I mentioned before, many of those returnees come to our society's disillusion, willing to break with the Islamic State violence, bring to reintegrate themselves into our societies. So I believe that to insert returnees in our terrorism threat models, we should adopt a case-by-case approach, rather than adopt a generic approach that is based on over-optimistic hopes or over-pessimistic fears. And for this case-by-case approach to be effective, I believe that there are a series of points that we should focus on, even though it's a very difficult assessment to make, as Tanya made very clear before. And I'm referring in particular to the experience that the returnee underwent within the Islamic State. So it is important to know as much as we can if that experience was administrative, military, if the returnee was involved in combat roles. And here it is important not to fall in false gender assumptions and assume that female returnees are necessarily unharmful. Secondly, the commitment that the returnee maintains to the Salafi jihadist ideology, and specifically it is important to assess whether the person is disillusioned with Salafi jihadism or rather still committed to the ideology and just disappointed with the performance of the Islamic State, or rather whether the individual is still devoted to both the Islamic State social project, political project, and the ideology behind it. And finally, the third point that I believe is important in our assessment of returnees and the threats that they might pose is the reason why the returnee has returned to the home country. If it was because of pragmatic reasons, survival, physical security, need of medical care, if it is an ideological reason, as I said before, the disillusionment with the project and the desire to return to our model of society, or rather whether the individual is returning because of the desire to continue the Islamic State project in the home country. So I tried during this presentation to shed some light on how the Islamic State saw and sees today its returnees. I couldn't cover a lot of other points, but I would be happy to do so in the question and answer session. Thank you.
Excellent. Thank you, Marta. We'll now turn to questions and answers from the audience. I see a lot of excellent questions in the chat. I hope we'll get to have our panelists answer most of them in the 12-minute period. The first thing I'll start off with is sort of the news that's most hot off the presses when it comes to this topic. And I'll pose it as a question to all panelists about the extradition of the Beatles to the United States to face trial. For Dr. Pokalova and Ms. Mehra, I guess the question about this extradition is what precedent does it set for efforts among different countries in the West that essentially the United Kingdom has placed its responsibility for prosecuting its own foreign fighters on the United States. What ramifications would that have from a political perspective? And what does it have for a legal perspective that the United Kingdom chose finally to send its fighters to the United States for prosecution? And the way I'll pose this question to Marta is, do you see a strategic discourse within the Islamic State regarding its fighters that had returned to their countries of origins but were prosecuted and put in jail? And is there any effort from the Islamic State to try to encourage its supporters to support its imprisoned fighters or even attempt to free them in some aspect?
So I'll go ahead and get started on the answer to this very important question. The thing here is that different countries have different legal standards. And as I was mentioning, different countries adopted new legislation, but some countries have relied on their existing counter-terrorist legislation in approaching foreign fighter returnees. And in this respect, the US is sort of in a privileged position, if we can say so, but the experiences of September 11th introduced the legislation to deal with terrorism, which is quite expansive on the one hand, but on the other hand, it allows to try different crimes that might not be easy to prosecute in other courts, for instance, in the UK. And here in the Beatles case, we have two individuals who have been known to torture people and commit grave assaults on human rights in Syria and Iraq. But at the same time, as Tanya was pointing out, the evidence collection process is so complicated that we might not have evidence to prosecute them in certain courts, but not others. So you're correct to point out that this does set a precedent of one country sort of pushing its problems onto another, but at the same time, the issues and the complications in terms of prosecuting these individuals, that remains an issue, and countries need to probably look into counterterrorism legislation to figure out how they want to proceed in terms of redefining the standards and adopting them to the current threats.
Thank you, Elena. Just to follow up on that, I mean, this case is a little bit different. In this case, the crimes have been committed against also for American victims. So the US is asserting jurisdiction based on passive nationality principle. And they are, for many other countries who have adopted international crimes in their criminal code, they can also assert jurisdiction on the basis of universal jurisdiction. And in fact, in Germany, we see some of these cases, they have already started. So I think the message from the US is very clear. They will bring their own foreign fighters to justice, and they will bring everyone to justice who have committed crimes against Americans. And the fact that the UK, if one would like to consider that, has passed on the bucket, yes, they deprived them of their nationality, but the question still remains, at the time when they commit crimes, they would have the UK nationality. And in most countries, they are able to prosecute these kind of crimes on the basis of jurisdiction. I've written an op-ed specifically on the Beatles, in which I explain which countries could and couldn't prosecute the Beatles and the issues relating to mutual legal assistance, because one of the issues was the death penalty assurance, and that's why it had taken over nearly 8 years before. These two gentlemen are facing justice in court. And if I may, I could already right away answer the question by Phil Gursky on whether these can prosecute. They certainly commit in the country. Have already to prosecute. The question is whether, if it are our citizens, they need to stand here that you are a citizen, and so you can maybe date
Tanya.
And other violent extremist groups than the opposite.
Tanya, unfortunately, we're having some difficulty with the internet. Okay, the internet connection on her end. We'll give her a chance to answer that question after, but we'll turn to Marta.
Yes, so responding to your question, I believe that in the case of those individuals that do not return voluntarily, individuals that are repatriated, the main message coming from the Islamic State, both in the case of males and females, is to keep strong, to remain faithful to the project of the Islamic State, and kind of prepare silently for the resurgence of the group. In the case of those individuals that are not indicted, that for one reason or another do not spend time in jail, but might be monitored by the security services of our countries, the Islamic State then, I believe, approaches them in the same way in which it approached and used to approach those who could not make hijrah. For instance, last July, it released a video, a message called Ending Side with Believers, in which it was encouraging its supporters in the West, outside of Syria and Iraq, to perpetrate attacks in the home country. And it was in particular recommending to those who are under monitoring mechanisms, such as returnees are most likely to be very careful in preparing the attack and in eliminating all the evidence of their connection to the attack, to the scene in which the attack had been perpetrated. Well, in the case of those that are put into jail for a shorter or longer period, I don't see a breaking the walls campaign on part of the Islamic State. I think this rhetoric and this intention to liberate prisoners is not realistic when it comes to the West. I think it's more something that the Islamic State is planning and hoping to do in Iraq and Syria.
Thank you. Because of the internet difficulties from before, we'll get some thoughts from Tanya and any other panelists that would like to answer this question. Just to rephrase it, the question is, you know, the folks who participated in the Islamic State have committed crimes in Syria and Iraq, especially for Iraq, which is a sovereign state. If you've committed a crime in Iraq, why should Iraq not have the first right to be able to prosecute you instead of you being transported back to your home country for prosecution in the case of returnees? Also group this with another question about alternatives for prosecuting foreign fighters that don't require repatriation. What do you think is the likelihood or the possibility for a UN tribunal to address some of the questions related to prosecuting foreign fighters? We'll start with Tanya, and then any other panelist that has something to chip in on this can take a shot.
Yeah, I know my internet is becoming very unstable, so maybe I'm repeating some of the things you said. But anyway, yes, of course, Iraq can prosecute our foreign fighters because the crimes have been committed in their country. But they have already a lot on their plate. They are also prosecuting many of the crimes committed by Iraqi citizens. And the question one needs to ask is whether or not we if we expect our foreign fighters to be prosecuted there and they might not meet the fair trial standards, whether that would be the right approach. So you treat them as second-rate citizens and you allow them to have a second-rate justice. And that narrative might be very misused by ISIS and other groups. We have the repatriate, and I think it's not only about the prosecution, and also tying into some of the issues Elena and Marta said, it's about framing the discussion. If you would repatriate them, it's a controlled risk. And as mentioned before, not all the
Sorry, it looks like we're still having some difficulties with the internet. We have a very short amount of time left. I'm sure there's some way for you to communicate for some folks that want answers to those questions as well, Tanya. But with our concluding minutes, any other thoughts on this issue of whether Syrian or Iraqi authorities should get the first shot at prosecuting ISIS fighters from Elena or Marta?
Sure. So I would second what Tanya was saying in terms of they have the right to prosecute those individuals on their own soil. However, I would caution against the time in detention and the efficiency, because we haven't really talked about what happens in detention, but there's further problems with radicalization and extremism when these people are held in detention. So what actually happens afterwards when they're prosecuted? Now, let's say in case of Iraq, if there is death penalty, that's one issue. But in other cases, if you don't have death penalty, then at some point, these people will be coming out of prison. And coming out of prison, they will be probably more radicalized than when they went to prison before. So a similar concern is with the international tribunal, because currently we can actually prosecute crimes of terrorism under the ICC, but we have seen how the International Criminal Court is not quite efficient and is not quite good at prosecuting cases in a timely manner. And again, I would say in these cases, when we have individuals with very radical ideologies, we might be cautious about putting them in confined spaces when they can actually radicalize each other, as opposed to more programs focused on their rehabilitation.
Excellent. Marta, I don't know if you have any concluding thoughts.
Yes, there is a point I would like to make. I would just like to stress the importance that Elena and Tanya previously mentioned about repatriating those individuals, because doing this research about Salafi jihadists and Islamic State approach to foreign fighters, returnees, it gave me the impression that they have a better plan than we have currently for those individuals. They are raising funds to liberate women from Al-Khol. They are trying to organize themselves to liberate foreign fighters who are imprisoned in Iraq and Syria. So either we act now or the Islamic State will.
Excellent. My apologies to everyone who had a question in the chat that we can't get to today, and probably talk about this subject, especially some of the more recent developments for hours. But I hope you will join me in virtually giving a round of silent round of applause, I guess, to our panelists who did an excellent job. It was a fantastic discussion. We thank all of you who are there in the audience for joining us. Again, this was simulcast to YouTube, so there will be a permanent URL of it available on the Program on Extremism's YouTube channel after the event. And once again, thank you to all our participants and panelists for an excellent discussion today. And have a great rest of your days.